Hello and welcome to Short Circuit. That's right. This is Short Circuit live from the University of Montana School of Law. I am so excited to be back in Montana. This is Anthony Sanders, the director of the Center for Judicial Engagement. And listeners may know that from time to time, we do these episodes Short Circuit live. Now, usually we talk about a federal circuit. We've done the Ninth Circuit, the D.C. Circuit, the Fifth Circuit, various circuits over the years. But today, for the first time, we're doing a state Supreme Court. You may say, but you're Short Circuit. Well, we also talk about state Supreme Court cases on Short Circuit from time to time. We've even done whole specials on state constitutional issues. But we're doing this on the Montana Supreme Court because I am at the University of Montana for a symposium about the 50th anniversary of the Montana Constitution. The Constitution I really think a lot of and I know a bit about because of my clerkship at the Montana Supreme Court. And so it's so exciting to be here so we can talk a little bit about the Montana Constitution and just Montana practice in general. Now, we have a packed room full of Montana students here to see us talk about various Montana law issues. But we also have three powerhouse Montana litigators with me today to talk about these different issues. And I'll be introducing them in a second. First, thank you to the organizers of this event, the Montana Law Review and the local Federal Society and American Constitution Society chapters for putting this all together. So we'll move on to our panelists. First, we're going to hear from Tasha Jones. She is a graduate of this very law school, the University of Montana School of Law. She then went on to clerk for Judge Sam Hayden of the U.S. District Court for the District of Montana. Where's Judge Hayden's?
Haddon.
Haddon. I'm very sorry.
No problem. He would not like it, but he's not here.
What city was that in?
I was in Great Falls, but he's now in Helena.
Okay, great. And both great towns to spend a little time clerking in. Then she went on and she has been a shareholder since 2008 in Boone Carlberg. She does all kinds of trial and appellate work. And she'll be talking about a case where she argued as an amicus at the Montana Supreme Court, that the decision that just came out a couple weeks ago. Next, we will hear from Colin Stevens. He is a part of Stevens and Brook. He is a graduate of Carroll College and the University of Montana. Like me, he got a graduate or a master's degree in philosophy, and we were just discussing they've come up very useful in our practice. I say that mostly tongue-in-cheek, but not entirely tongue-in-cheek. Then he went on to get a law degree from the University of Montana. And at Carroll College, by the way, when I lived in Helena, they were like a powerhouse football team. I mean, like repetitive national champions. You know if it's still that way?
It should be. But I think this year where we could be doing better.
Okay, rebuilding program, right. Perhaps.
When I was there, they still played at a middle school. So it's been a while.
Very good. Yeah, I went to one game there. It was a lot of fun. The fall I was there, and he is primarily a criminal practice at Stevens and Brook PC here in Missoula. And then finally, we're going to hear from Riley Summers Flanagan. She is the founder of her and her partner's own public interest law firm. Now, working at a public interest law firm, I know from stories I've heard from the founders of the law firm, that is not exactly an easy task. And so she should feel very proud of herself and the work that they've done at Upper Seven Law since it was founded a little over a year ago. She is a graduate of Stanford Law School, which is also where my co-clerk at Montana Supreme Court went when we clerked there. And she then went on to clerk for a trifecta of judges, Judge Sidney Thomas on the Ninth Circuit and Judge, I'm going to mangle these names too, Huville and Hogan. Get that right?
Very close.
Okay. Of the U.S. District Court for the District of Columbia. And she is going to talk about a case that she it has gone to the Montana Supreme Court on a preliminary matter, but it's going to they just had a trial in the trial court, and she is going to be anxiously checking her phone while we're talking to see if the ruling has come out. It's a voting rights case. And so we may break some news here on the podcast. We'll wait and see. But we'll give that a little bit of time. And first, we'll go to Natasha for a case. And I will give a massive disclaimer at the beginning. This is a case where Tasha was for an amicus for the cities on counties on one side, and the Institute for Justice signed on to a brief written by the MacArthur Center on the other side. But we can still sit here and talk about the case, and all's going to be fine. So tell us about LB.
Okay, so let me just set the stage about why I am talking about this case, because this was not my case, and we were asked to come in as amicus in that case. So I've been practicing for 22 years, and a very significant part of my practice has been working for an organization called the Montana Municipal Interlocal Authority. And what that is a collection of cities and towns that pool their resources together to provide defense and indemnity when cities and towns or their employees are sued for any reason. So that can be a slip and fall on the sidewalk. That can be a significant land dispute over zoning, something like that. Or it can be a claim or lawsuit filed against a police department or police officer alleging excessive force or some other violation of law related to law enforcement. And a lot of the cases are about law enforcement. Law enforcement officers have hard jobs and they get sued a lot. And we, cities and towns, generally speaking, get sued a lot because they are deemed to be deep pockets. They have resources, basically all of our resources, that stand behind them. And so there's just a lot of litigation against our cities and towns. And so that's the background that made my law firm appropriate to act in the role of amicus as it relates to this case, LB. We have not done a lot of work for the counties. So the counties have a similar association. And it's referred to as MACO. Colin actually worked for MACO a long time ago. But the same situation where it's a collection, there's membership. They provide defense and indemnity when county organizations or entities are sued. And we often team up with MACO because a lot of cases have both a city law enforcement agency, and then the sheriff's office. They have agreements where they back each other up. They appear at the same calls. And so there's a lot of overlap, but usually that's not my client. In this case, it was. In addition to that, my law firm and my partner, Tracy Neighbor Johnson, and I had some cases that were similar to LB. So we had represented the city of Helena as an example, where a rogue undercover law enforcement officer had engaged in consensual sex with 4 confidential informants. And when that came to light, he was going to be fired and resigned in lieu of termination and had his certificate revoked. And then those individuals who had been interviewed and said the sex was consensual then hired a plaintiff's lawyer and sued the city for tort damages for what they claimed to be inappropriate conduct on our part in hiring, training, supervising that officer. That case, we won on summary judgment because the judge said that conduct, sex with confidential informants, was not in the course and scope of his employment as an undercover agent. So there's why we got the ask. So let me tell you about LB, and this was not my case. So LB is a Northern Cheyenne tribal member living on the Northern Cheyenne Reservation in Lame Deer, Montana. In 2015, she and her mother left the reservation, and they went to a bar and they engaged in partying. So they were drinking together at a bar off the reservation. They returned home to the reservation, and the mother took the keys and said she was going to drive. Her daughter called the cops and turned her mom in for drunk driving. A Bureau of Indian Affairs agent, a BIA agent, federal agent, named Officer Dana Bullcoming responded to the call. Officer Bullcoming went to LB's home and she, investigated the circumstances surrounding the mother's intoxication. They figured out the mom was safe, all was good there. But while he was in the home with LB, he questioned her, and she was intoxicated herself. And she disclosed that she had been drinking. I think there was evidence she was visibly intoxicated. And he threatened to call social services and arrest LB for violating tribal code that prohibits intoxication within the reservation boundaries. The Cheyenne Reservation is a dry reservation. The two went outside, and he performed a blood alcohol test on LB, and her BAC was either 0.132 or 0.136. She couldn't remember which. Clearly, she was very intoxicated. At which time the officer allegedly, repeatedly stated, something has to be done, kept saying that, something has to be done. And LB, catching the hint, said, "Do you mean sex?" And he said yes. So they went into the home. They engaged in unprotected sex that resulted in pregnancy and the birth of a child named DB. Those are the facts. Now, again, before you get mad at me, this is not my client. This was not my case. I was not involved in any of that, and still I'm not involved because that case is ongoing. So this case went to the Ninth Circuit because summary judgment had been granted by the federal district court judge in Billings over course and scope. And at the Ninth Circuit, when they were analyzing the issues presented there, they issued a certified question back to the Montana Supreme Court, asking the Supreme Court to determine, there was some conflict in the law, also some cases that we had worked on at Boone-Carlberg, about whether or not this behavior could be considered to be within the course and scope of employment. And the question was, as reformatted by the Montana Supreme Court, under Montana law, do law enforcement officers act outside the scope and course of their employment as a matter of law when they use their authority as on-duty officers to sexually assault a person they are investigating for a crime? So there's the question posed to the Montana Supreme Court. So the plaintiffs filed appellate briefs, and there were multiple amici that were filed on the plaintiff's behalf. The federal government filed an appellate brief, and then we filed a amicus brief arguing from the perspective of cities and towns. And our perspective really was that our cities and towns are overburdened already, that municipal governments are underfunded, and that includes law enforcement agencies, and that if you impose strict liability for intentional criminal conduct, it will have a ripple effect. And that is why this type of decision should be left to the legislature. And we said you need to hearken back to a case called McGuire, where that court said if there's going to be a change in this area of the law, it needs to come from the legislature. So that was really kind of the gist of our argument. So what happened? Some of you may have seen the oral argument, and you will know I didn't get enough time. So I was so happy to come here and say all the things that I should have said then that I didn't get to say because I didn't have enough time. And of course, how that works is, you each get 30 minutes, and I had a gentleman that went first, and he took too long, and I didn't have enough time left. So
We
unfortunately,
know that story well at IJ, by the way.
right. I know it. Yeah. Okay. And then, so what happened? Well, darn it, they came to the wrong decision. Unfortunately, the Montana Supreme Court issued a 5-2 decision to the certified question. The decision came down McKinnon, McGrath, Baker, Gustafson, and Shea, in case you're interested in that. And then Judge Sandifer dissented, and Justice Rice, joined in the dissent. So what does this mean? This means that that now this decision is in conflict with existing Montana law. So let me read to you the law in Montana right now. Under Montana Code Annotated 29102, governmental entities are liable for torts except certain categories, right? And a governmental entity has a duty to defend and indemnify its employees except, and this goes to 29305, if the conduct constitutes a criminal offense. So now we have a decision that says it's a fact issue as to whether or not this is within the course and scope of employment, raping somebody on the job. And the law that says, let me be more clear about this. Government employees may not be defended. You cannot defend them, and you cannot indemnify them if they engage in criminal conduct. So we got a real issue here. So the majority said that McGuire is still good law but doesn't apply here. They did criticize it, but they said it simply did not apply. And in that case, just briefly about McGuire, so that case was a worker in a center for extremely developmentally disabled individuals. That worker's job was to care for a very disabled person who was nonverbal, and in the course of that care, raped and impregnated the victim. And the Montana Supreme Court said not in the course and scope, and if there's going to be a change, it needs to come from the legislature. But our majority court here said that doesn't apply because they did not review the issue. In their opinion, I think that was incorrect, but they did not. They said McGuire didn't touch upon the relevant things. It came down to this issue. The decision in LB came down to whether there was a mixed motive. And if you were at the oral argument, do you remember I quarreled with Justice Sandifer about this issue, right? I said, never is there a mixed motive for rape. Never. That is never a part of a law enforcement officer's job. Unfortunately, the majority disagreed with me, and it appears Judge Sandifer, who wrote the dissent, because they said that it was an issue of fact as to whether or not, when the officer used his authority to basically bully LB into sex, that he may have also, in addition to gratifying himself sexually, wanted to save taxpayers' money by issuing a warning rather than arresting LB, and that was an issue of fact that a jury needs to decide. And so on that basis, they kicked it back to the Ninth Circuit, answering the question that Montana law does not clearly state that this type of conduct is outside of the course and scope of employment. Let me just talk a little bit about the dissent. It was my favorite part, right? What Justice Sandifer said was that the majority had earnestly applied clear and consistent precedent on the issue of respondent superior. And remember here, what we're talking about is direct liability on the one hand, and indirect liability, which is vicarious liability here. So if you negligently hire, train, supervise an officer, a department can be held directly liable for that under negligence. Here, that wasn't the case. They're saying that you didn't do anything wrong, but because the officer committed a crime, you're on the hook for that criminal conduct. And so Justice Sandifer said they erroneously applied consistent and clear precedent in a result-oriented manner to reach a desired ad hoc result. Because, this is what he says, they wanted to provide a remedy, make the government financially liable to an innocent victim for outrageous, tortious criminal conduct of a rogue law enforcement officer. That is the words of Justice Sandifer, not me. He also said that their analysis was patently erroneous and in manifest absence of any record. There was no evidentiary basis upon which a finder of fact could reasonably conclude that the officer was acting with any motive or purpose other than for his own sexual gratification. So you can see here, that was really the tension here, is who gets to make this call, a jury or the judge, as a matter of law. And from Justice Sandifer's perspective, the record wasn't clear enough, and it was just going to be speculation. Now, remember, I had that same argument if you saw the oral argument, I had that same discussion with Justice Shea. He wanted this to kick this to the jury, and I said, that's a terrible idea. That's a terrible idea. Why? Because never is sex a part of the job. Never are you forwarding the interests of your employer when you cross the line as a law enforcement officer and you engage in sex with anybody. You're a criminal at that point. So that's the tension there.
Tasha, and if I can ask a question a step back, that the reason why this was a certified question is because, is it right that under the Federal Tort Claims Act, the government is liable if the employee acts within the scope of their employment? Is that long story short?
And then that analysis goes to Montana law.
Goes to the state law.
Right. So there is a reference under the Federal Tort Claims Act that you need to resort to Montana law to make that call. And then that's where the conflict was. Right.
And one other interesting part about this story that regular listeners will know about a bit about the FTCA, the act we just talked about, and then Bivens claims, which are claims against federal officers in their individual capacity. This fellow was sued under Bivens, but he didn't even show up to court, so they did get a judgment against him.
Correct.
A default judgment, but of course he's not going to. I think he's in prison now, or he was in prison, so he's probably not very able to pay that judgment.
And that's right. I mean, so the issue here, and frankly, the issue for many victims of crimes, there was no money to make that victim whole for the clear damage that had occurred to her and her child. And the bad guy was in jail, and he had nothing anyway. Even if he was out of jail, he didn't have any money, right? And so, should there be a remedy? And this was the poll, right? I mean, that's a very emotionally charged argument. And what we were suggesting to the Montana Supreme Court is that's a legislative issue, right? That the legislator is best suited to determine whether or not we needed, as citizens, to decide that a certain segment of criminal victims should have a remedy when the tortfeasor, the bad guy, doesn't have any money.
Right. And even though this was against the United States, the Montana units of government are sitting in the background because of the precedent that the case was set. Right?
That's right. So that's why we came in and were allowed to come in, because this ruling affects all of us in all Montana communities.
Riley, you have any thoughts on the ruling?
I think that I will just compliment Tasha for how incredibly clearly she has laid out these issues, and I think also presented the real tension in the case, because I think that when we are thinking about issues like this, I probably land on the side of I haven't read the decision, so I hesitate to question the majority's reasoning. But based on your presentation, to me, it seems much clearer that we should just, when officials are acting in their official capacity, they should be held liable for their actions. And the state should also be held liable for their actions, because states have a responsibility for their, for the folks that they employ in training and all of, but it does present genuinely difficult questions around funding, especially for smaller government bodies. And so I just, Tasha's presentation of sort of what the issues are seemed to me very clearly right, regardless of which side we end up landing on,
It's really tough issues, right? I mean, what could there be a more sympathetic victim here? Right? I mean, and at the oral argument, we saw the first speaker was the amicus talking about violence against Native American women, and true story, big issue. Sexual assault, big issue, societal problem. But there are many, many victims of crimes who go without remedies, and so without sufficient monetary remedies. And let me give an example. So if you've been wrongly accused and you've been in prison for many, many years, and then you are let out of prison because now we have DNA. As a state, we have now passed into law a legislative structure where you can go and seek payment for those years when you have been wrongfully imprisoned. So our state has decided that as a matter of public policy, we want those individuals to have a remedy. And I personally agree with that because, and been involved in these cases personally, but because to relitigate the innocence or guilt of somebody after they've spent 20 years in jail, and the folks that originally testified are dead and gone or unavailable, very, very difficult to do. And so we can't take those cases through normal process. So we created a structure. And so that's what we were suggesting is these issues are very hard to deal with. But making a law enforcement department strictly liable for intentional criminal conduct, our argument, doesn't stop the original crime. In fact, it may encourage it, right? So what should be a deterrent to a police officer is that if I engage in criminal activity, if I use my badge to be a bad guy instead of a good guy, I am going to go to jail, and then someone is going to sue me and take my house and my car and my retirement account and ruin my life. That is a deterrent. Now, if a police officer is faced with that quandary, do I turn bad guy at this moment? That officer knows I'm going to get a lawyer for free, and the department has to indemnify me for damages because there's strict liability for intentional criminal conduct. I mean, so again, as a matter of policy, that was the argument that we were making to the Montana Supreme Court. Don't do this. This needs to be a legislative analysis. We also presented evidence about the statistics about law enforcement officers who engage in this sort of behavior, because clearly sexual assault is a big problem. Clearly, violence against Native American women, big problem. But the data to say that sexual assault by law enforcement officers is not evidence of a systemic problem. So we presented statistical evidence based on an analysis of claims against law enforcement officers from 2013 to the present day to show that this is not a problem in Montana, and that is conflating big picture problems, sexual assault generally speaking, violence against Native American women generally speaking, but to connect that into sexual assault by law enforcement officers, that the data isn't there. And so we were saying you really can't tie these things together.
So we could talk about this for hours, and I would like to, but to stay on our short circuit schedule, we'll move along. I think that's a terrific presentation of the issue, And I will say that I'm glad, even though he will not be able to pay it, this man actually did get a judgment against him, which often is not true, of course, when officers are sued for reprehensible conduct. So I hope that this can lead to some reform in Montana legislatively, because we can always have that as the legislature can always address the issue in a better way. The biggest thing is for Congress to address the FTCA and Bivens remedies, but that's something we've talked about in Short Circuit before and will many times again, so we'll leave that to another day. Something I left out at the beginning is to talk just a little bit, we'll talk just very briefly about practicing before the Montana Supreme Court and what the court is like. So the court is 7 justices. It has a right of appeal from any final judgment from state court because there is no intermediate appellate court in Montana. It's one of the last states left without an intermediate court, which makes things interesting when you're clerking at the court and all the kinds of cases you get. But any of you want to say what you think the listeners would want to know about Montana's court system, Montana Supreme Court versus practicing elsewhere?
Well, I think there's been a lot of politics around our Montana Supreme Court in Montana lately. So I would just point out a few things that makes Montana, like some states and different from others. Our Montana Supreme Court justices have to run in statewide elections. And so I say that because that is a difficult thing to do and a very expensive thing to do. They are nonpartisan elections. And so, it's not supposed to be about Democrat versus Republican, but, it's an expensive endeavor to run a statewide campaign. And they come to the table with their own particular experience. And it's the first thing that I looked at when I'm going to go argue before them. I pulled up their background so I could remind myself of whether there was a particular background that would be relevant to the case. So as a practice point here.
Like Justice Sandifer, for example.
Right, exactly. I was going to say, so you may not know this, but Justice Sandifer was a law enforcement officer. Yeah, so, and then many of the other justices had criminal backgrounds experience on one side or the other, prosecution or defense. And then not very many of them had civil background. And so that was important to me because I wasn't commenting on the criminal law, right? I was saying, you got to think about the ramifications in the civil tort arena and what this could mean. So their backgrounds were important to me.
And Colin, we were talking before we started taping about how the court could use a little more oral argument, you think at times, for some friendly suggestions from the podcast here.
Right. I'm always the appellant. So I get 40 minutes, I think, when I argue with the court or before the court, I should say. Maybe not. And that's a long time to make a point. My theory is that they should be doing more oral arguments, less time. Oral advocacy is a skill, which I have yet to perfect. But all of you in this room are going to face very small opportunities where you will get to argue before a court of appeals, be it the Ninth or the Montana Supreme Court. So more oral arguments, the better.
So less equals more in this case. It could equal more.
Yes.
Yeah. Do you agree, Riley? They could use a few more arguments there.
I mean, isn't it just more fun?
Yes.
I feel like they should want to see our happy faces. And I also think 40 minutes seems like it would be a very long time to be talking to a court, depending on how many questions it may have. And, that can really vary dramatically case by case.
Yeah, they've started. So I've argued, I think, in front of the court 7 times, maybe 6. When I first started, they were great. They would just sort of jump right in. And now they have sort of extended this, like, we're going to let you talk for a little bit.
Following the folks in Washington?
Yeah, and I hate the sound of my own voice. And you didn't invite me here to listen to me talk and just read my brief verbatim. So I usually try to go in and say something incredibly controversial. And it's usually Justice Sandifer who will then lean in with his cop attitude and say, counsel, and then we're off to the races. So it's fun. I mean, it's my favorite part of practicing law is oral advocacy at the Ninth at front of the Montana Supreme Court.
Yeah, when I was clerking, it was always fun. We rotated, so it's that you were the clerk that day with the gavel, and that was the one day you would actually wear a suit in that job. Every other day you wear jeans, and tap tap tap, and start the argument. But there were so few of them. It was almost like there were more attorney discipline hearings because those were the public and in the well when they discipline an attorney than an actual oral argument. I think we had like 2 a month, or one case one morning. So otherwise, fantastic place to clerk. Helena's a great place to live. I recommend people listening out there to apply if you're applying to clerkships in the future, but maybe a few more oral arguments. Now, I don't know if this case got oral argument or not. It did not, but it did get an interesting concurrence. So Colin's now going to tell us about a state versus well-known.
Yeah, so I'll start. I'm a criminal defense lawyer. I'm not a powerhouse, and so I guess thank you for that. But if I did, it would have a crescent moon on it. Oh, did you get breaking news?
No.
Right.
I just wanted to say that the reason I haven't argued before the Montana Supreme Court is that the state keeps refusing to appeal when we win.
It's always very frustrating.
And from my perspective, thank you again.
Yeah.
Riley represented my organization. Okay, state versus well-known. I don't like talking to unknown people on the internet, so I'm going to talk to you folks. It's a criminal case, and basically at the end of the day, it's about a Batson challenge. Anybody here know Batson? Okay, not personally, right? I'm not asking personally. Does anybody know what Batson is? Maybe down there. I see one hand. Okay, so Batson is voir dire issue. It is unconstitutional to exclude people of race, people based on their race, foreign, national origin, or gender. So that's Batson in a real short form. State versus well-known. Mr. Well-known was on trial for a felony DUI in Billings, and Mr. Well-known is native. So Billings being the hotbed of let's see, I'll just pull up the statistics. Yellowstone County, basically you want to lump it into 15.4% of minority or mixed race individuals at the time of the trial, at least according to the 2020 census. There's one Native American on Mr. Well-known's jury, a guy I think by the name of Ground Spring, or Birding Ground. So I'm might pronounce that wrong. Anyway, so one Native American in the veneery, and the state doesn't ask him any questions. Prosecutors tend to, no offense if there's a prosecutor out there, but they do voir dire in this very kind of third grade way where they will say, they'll posit something and then say, does anyone here disagree with that? And, my colleague just had a case where it was child sexual assault, and the prosecutor stands up and says, who here likes child sexual assault? And, that's not a question. So anyway, the state, from what I can tell from the record, it wasn't my case, does their usual rigmarole of who thinks drunk driving is good, who here's had a loved one who's been affected by drunk driving. So Mr. Burning Ground in the veneery doesn't say anything. State passes the jury for cause. The defense asks, everyone some questions, and defense lawyers do tend to do a better job because I always feel like we're behind the 8 ball. So we will single people out, and say, I noticed when the state asks you a question about whether you like child sexual assault or not, you were somewhat reluctant to raise your hand. It didn't shoot up like you were being electrocuted. What do you think about that? That's a bit of a reductio, but I think we tend to drill down more. So anyway, prosecution comes around. Eventually the defense passes the jury for cause. Prosecution uses its peremptory strike on Mr. Birding Ground. So at this point, the record gets a little muddled. Trial counsel then says, hold on, I'm going to make a Batson challenge. The state did not. I want the state to present a non-race-based reason for why it is striking Mr. Birding Ground. And so then the state, which, bless him, prosecutor comes forward and says, well, I know we didn't talk about this before in voir dire, Judge, but Mr. Birding Ground was actually the victim of a violent sexual assault at the hands of his girlfriend. And, oh, by the way, he was very uncooperative with us, and we eventually had to give his girlfriend a deal. So his hostility to the prosecution is one of the reasons we're striking him. Judge says, great, the Batson objection is overruled. Moving on. And then all of a sudden the state comes in and says, oh, and Judge, by the way, afterthought, when Mr. Birding Ground was asked questions about the presumption of proof, he said he'd have to be 100% certain before he convicted. And that's not the standard. And the judge just sort of yada, 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 I'm standing with my decision. So, Mr. Well-Known is convicted. Otherwise, we wouldn't be here and I wouldn't be talking about this. And so it goes up on appeal. And I don't know, for those of you who are unfamiliar with the public defender system in Montana, you've got trial department and then you've got an appellate department. And so the case then gets handed off to the appellate department, who can then read this record and go, you know what? It's a good Batson case, but this would be a wonderful time for us to raise the dignity clause of the Montana Constitution, Article 2, Section 4. It's amazing. If you haven't read it, you probably shouldn't be sitting in here. And the dignity clause is sort of this vast umbrella of protection and recognition of race and social structure and culture that extends so far beyond Batson that it makes Batson essentially the Stone Age. So Well-Known is it's somewhat of an unremarkable case because the majority just says, well, the district court didn't exactly do it right, but it's interesting. In the briefs, in Mr. Well-Known's brief, 35 years between Batson and Well-Known's case, the Montana Supreme Court has yet to sustain or reverse on a Batson challenge. For various reasons. But anyway, so the majority just kind of is like, well, you didn't raise this dignity clause at the trial level. You didn't raise it, so we're not going to consider it. It's not plain error. Denied. And in comes Justice Baker, who's awesome, and she has a concurring opinion. And she says, I agree with the majority's opinion, but there are issues that are raised by Article 2, Section 4, and that are evolving in our society with unconscious bias and implicit bias that we need to start working on. And so for, I think, Justice Baker, had defense counsel said, Your Honor, I object, Batson and dignity clause, this case probably would have had a different result. Justice McKinnon has a comment in a past case where she concurred, where she seemed to have suggested that, the dignity clause and an expanded sort of equal protection recognition of various other protected classes would be available. And it's just fascinating to me because, Batson is a really narrow group of protection. The Ninth Circuit came out with a decision, August 22nd, I was just reading as I was doing my last-minute homework for this. And this was a prosecution out of California where the prosecutor struck Hispanic females. And the defendant said, objection, Batson. And it churns through the lower courts, comes up on a federal habeas, and the Ninth Circuit says, well, that's not, the prosecution kept Hispanic males, and it kept males, and so you're trying to do this mixed race protected class that doesn't exist, and it's never been recognized, so your appeal's denied. And it's an interesting case, and I think it's definitely fertile ground for those of you who go out and want to be trial lawyers and who want to drill down in with jurors. Remember the dignity clause. Justice Baker also, and I will just say, she has a footnote, it's footnote number 8, where she says she's directing, so she's sort of encouraging the various committees that the Montana Supreme Court has to start recognizing implicit and unconscious bias. I think now there are draft jury instructions that are going to go around that are part of the preliminary instructions that judges will give that address unconscious and implicit bias. So her concurrence may be just that, but I think she's going to be the cause of real change.
It's always in the footnotes, isn't it?
That's where the best stuff
happens.
Right? I mean, like Lochner's got brilliant footnotes. So,
Caroline products, as we all know.
Right, exactly. So it's fun, right? I mean, there's this, well, the birth certificate challenge that just sort of got decided today. The Department of Health and Human Services filed this, we don't want you to change your birth certificate, right? Because sex is an immutable characteristic. And, back in the 70s, that was rah-rah, right? Immutable characteristics get you equal protection challenge. And now it's sort of this weird shift between ideology where, it's the more conservative groups that are saying, well, no, this is immutable, and others are saying, no, it's more fluid. So it's just a fascinating issue. And again, I will emphasize, I'm a criminal defense lawyer, and torts, and I mean, if you talk to my clients, cops are always metaphorically doing what that cop did. So yeah.
Well, we've seen both
SOP.
sides of the coin here today. But a different coin is people going to vote. So, Riley, tell us how you get to vote in Montana, and how the rules might be a little fluid, changing. We're not sure what they are exactly right now, but they may change because of a trial that just happened.
I hope so. And Anthony, I have to say, you did a really nice job of getting three people who are going to talk about like totally different things.
That's what Short Circuit's all about.
It's fantastic.
That's how we short circuit. It's
perfect. And then you can see all the parallels and relationships between different areas of law, which is the most fun thing. I was just litigating a very exciting voting rights case where three restrictive voting laws that were passed during the 2021 legislative session were all on trial. There were actually 4 laws initially in the case. We invalidated one of them on summary judgment before the trial. That law, just so folks know, was one that would have restricted 18-year-olds from receiving their ballot until they actually turned 18. And so essentially what the legislature had done, and many people in this room are aware that in Montana, more than 70% of Montanans vote absentee. So we receive our ballots in the mail. They're sent from election offices 25 days before Election Day. They arrive in your mailbox. You can return them in person. You can send them back by mail. These are really sort of lovely facilitative rules that we have that allow people to participate in democracy. The law that was passed, HB 506, essentially said that election officials cannot distribute ballots to people who do not yet meet their age and residency requirements. So that's people who have moved in the last 30 days or folks who are turning 18. Essentially, our argument was you can't discriminate against folks who turn 18 in the month before Election Day and allow them less access to the ballot, right? If we say that you're eligible to vote if you're 18 on Election Day, then you're eligible to receive your ballot at the same time as older Montanans. The court agreed with us and permanently enjoined that law before the trial started. We then went to trial on 3 laws. This was a very complicated case, and I will not explain all of the moving parts, but I will just say there were 3 plaintiff groups that had been consolidated. My clients are youth organizations. They're youth civic engagement organizations, Forward Montana Foundation, MontPIRG, which is the Montana Public Interest Research Group, and Montana Youth Action, which is a truly fantastic organization of middle and high school students that do civic engagement education with their peers. These 3 organizations were essentially litigating these laws from the perspective that whenever you introduce burdensome laws on the electorate, they are going to land more heavily on young people. You can sort of this is intuitively true. Whenever you do something for the first time, it will be harder than, come a year later or further down the line, you get better at whatever it is. Young people are in the particularly, I don't know whether it's an enviable position or not, but when you're turning 18 and you're becoming an adult, you are doing a lot of things for the first time. And voting is neither the most important nor the least important of them. And so we think it's really important that when we think about voting restrictive laws that create complications or burdens or challenges for people, that we understand that those are going to impact certain populations more intensely. So the other 3 laws that were on trial, and don't worry, this is quick. One of them, we can do them really fast. One of them eliminated Election Day registration in Montana. Montana, since 2005, has had Election Day registration where you can show up at your local election office and you can register and vote on the same day, and you can do it on Election Day up until 8 p.m., right? It rolled that deadline back to noon the Monday before. Noon, I don't know why. Not confusing at all, I'm sure. So that elimination is a really important thing because it impacts a huge number of people. But specifically, it impacts young people. People who are 34 years or younger in Montana use Election Day registration at twice the rate of older Montanans. So they vote using Election Day registration at a rate of 30%, whereas older Montanans, it's about 15%.
It's a millennial thing.
Yeah, we're just into it. I mean, I will say, though, right, that millennials were constantly being replaced. Now it's Gen X, right? And there will be another generation. And we should care, I think, about the fact that these are the people that we put all our hopes and dreams on. Every new generation, that's what we're doing. We're saying that the young people...
Gen X never had any hopes and dreams. It's true. Yeah, you mean Gen Z.
That's what I meant. I'm sorry.
Over Gen
You're
X.
Yes. Oh, thank God. It's an important correction. Yes. Sorry, Gen Zers. But, I think in seriousness, though, that the students in this room and the undergraduates on this campus are the people who are learning as we speak, right? You are the closest to everything that is new and all the cutting edge information in the world. And that it never stops being true, even though we sort of carry an identity with ourselves going forward. Like, I feel like a young person still, even though I'm now 34, and so I'm not as young as I used to be, but I still count as one of those people. So if I used Election Day registration, I would be adding to my generation's active use of it. Bottom line, it eliminated Election Day registration. This has a huge impact on young people. It also has a huge impact on Montanans at large. Thousands of Montanans in every single election cycle use it. Also, when we talk to election administrators about this, while they say it can have a minute impact on their day, election officials get up at 5 a.m. on Election Day and they work until 2 a.m. And that I have heard over and over again, and they tell us that it will not change if you get rid of Election Day registration. Legislature tells us that the reason they're getting rid of it is because of the administrative burden on election officials. That's not true. So you got to show up and you have to have some facts, and they couldn't do that at trial, which was a very fun thing to see. I highly recommend attending trial.
Not having facts?
I know, shocking. Like, what is this? Yeah. No, they didn't have facts, and they told us that the legislature can make whatever laws they want to disenfranchise voters, and they don't need to justify the decisions that they make because they are the legislature. And really, the legislative authority, the Constitution endows them with that authority. There is a great recent Montana Supreme Court case that counters that perspective and suggests that in fact, the Montana Constitution is not a grant of legislative authority, but instead is a check on the exercise of that power. So 2 more laws. One of them barred paid ballot collection. This was hugely important, specifically for Western Native Voice and for other organizations that work especially on the reservations. Mail service is significantly less reliable. This was not one of the laws that we challenged because we felt that the tribes and Western Native Voice were best situated to explain the impacts. although it does, of course, impact young people as well. And then the last law was a complication, essentially, of voter identification laws in Montana. So young people, in particular, are likelier to possess a student ID. And this law made it so that if you're going to use your student ID to identify yourself at the polls, you're going to need a secondary form of identification. And in Montana, historically, we have never needed two forms of identification, regardless of what kind you showed up with, as long as it fit within the statutory criteria, either had your name and your photo or had your name and your address on a government document, good to go. This law created a hierarchy in the identification preferences, and it required it put student ID in the second category. So it required it to be presented with a secondary form of identification. To me, this seems facially discriminatory. There were comments made in the legislature about how they wanted to see students have more stake in the game, and that they questioned whether or not students with Montana University system issued student ID actually live in Montana. I will say that I think it would be difficult to get that form of identification if you were living elsewhere, but, what do I know? So those laws were on trial. It was a very fun case to litigate. We had incredible witnesses. It was sort of riveting the whole time, assuming that you like expert witnesses.
To a judge or a jury?
To a bench trial. So Judge Moses, who actually issued the order this morning from the bench on the trans birth certificate issue, we are waiting with bated breath for his opinion.
So when that ruling comes down,
yes,
how quick can it get up to the Montana Supreme Court?
That is a question that we have been trying to figure out. We expect that it will be appealed regardless of the outcome. Mm-hmm. And our best guess for sort of how this will progress is that there will be a near immediate appeal. I believe that the state expects to lose and is preparing with the $1.3 million that have been recently appropriated to the Secretary of State to defend against challenges to election laws. This happened earlier this week, and we were a little surprised to hear of so much money being spent on an outside firm hired to represent a state entity, essentially to justify laws that disenfranchise voters in Montana. And doing so when we know we've seen cases in the past where the government has, and I realize this is not your question about how it gets to the Supreme Court, but it is really important.
Isn't it, though?
Yes. So
I have a question about that in a minute, but keep going.
Well, so the only interesting thing that I think is worth sort of having in mind when you think about that $1.3 million figure that was tweeted yesterday after the committee met is that, under the prior gubernatorial administration, the state has to sometimes pay for fees, whether it's from other attorneys who are litigating cases or it's to pay outside counsel. That does happen. There is an example of a case where fees were paid to the ACLU for prison litigation that lasted for 10 years. Those fees were paid at the rate of $900,000 for that full 10 years of litigation, approved by the governor's office, sent out the door. It's the way that these systems work. But to compare that to fewer than 6 months of legal work done by a law firm just to defend a set of laws on their constitutionality. We're not talking about prison conditions. We're not talking about people's, being in situations where they're having real sort of torts enacted against them, right? We're talking about laws that the legislature passed that they didn't carefully consider, that have very little in the way of justification to back them up, being defended as though the defense attorneys are an insurance company coming in and litigating literally every, filing motions after the trial to get deposition transcripts in that they didn't manage to get in beforehand on the proper schedule. That's crazy. I don't know how fast we're going to get to the Supreme Court, but I will say that everyone wants to move quickly because having those laws, and I know that that's true for folks on the other side as well, I think that fundamentally, at least I really hope that we're all on the same page, that like having clear laws for voters is extremely important. And we do know that when we change things and we complicate things, that makes it much more difficult for people to get engaged and to understand sort of how to navigate the process, particularly because when you have organizations that are trying to facilitate that process for people, they need to know what the law is so that they can communicate it. So soon.
So soon. Well, that's good. And soon we need to end this podcast. But I do have just a big picture question on the work you're doing, which you often hear. And I don't know. We don't do voting rights. I don't exactly know where I come down on a lot of these issues. But a big picture question is, it seems like legislatures are really good, and we know this in, say, the property rights context, the economic liberty context, the free speech context where IJ litigates, that legislatures are really good at doing things that they think will help their own self-interest. So if a voting law is going to make the party in power, they think have less of the other side's voters come to the polls, yeah, they're gonna pass that law. A lot of those laws are passed on I'd say both sides of the aisle. They're passed, but it seems like in the long run, a lot of these laws aren't nearly as good at suppressing voters as they think they are. And the one that really comes to mind is voter ID, where it seems like we've had fights over voter ID for like 20 years now. And in the long run, it seems like most people vote. It doesn't actually have a difference partisan. Now, maybe some people don't vote, but that's made up for other changes. And so in the wash, like it doesn't have anything. But what do you say to people who say like, yeah, these laws, the motivation looks terrible, but it doesn't seem like it actually has much of an effect?
I think that's all the more reason not to pass them.
True, but where does that go to its constitutionality, I guess is the question.
Well, I guess I think that the impact of the laws, so we know a couple of things, right? There is actually very good data that suggests that you do see more restrictive laws tend to suppress turnout, more facilitative laws tend to increase turnout. That is like a well-established academic study. Don't quote me on numbers because I would not be able to say them. But there are different centers that sort of define what qualifies. Online voter registration is a facilitative voting law. Election day registration and same day registration, which we also have sort of over the course of the period of the late registration period in Montana. It's too much information. But the bottom line is that we know that those laws boost turnout versus suppressing turnout. I think the question, in terms of constitutionality, I think that we have a responsibility to sort of think about the Montana Constitution as its own document that, while informed often by federal law, also set out to intentionally raise the bar on certain topics. I think that suffrage is one of those areas. We don't the right to suffrage in the Montana Constitution is really clear. It couldn't be stronger than it is, I don't think. I also think that the ways in which the Constitution and sort of it guarantees the right to a free and fair election, free from interference of legislative, I can't remember all three of the things, but it's an incredibly strong provision. And I think when we think about laws, and I can't speak to the U.S. Constitution in terms of voting because I think that a lot of what has happened under federal law has really diminished the value in some ways of either the laws being passed or the litigation. Maybe it is a wash. But in Montana, it's clear to me that we value participation at an incredibly high level, and that our Constitution set out to protect the right to vote in an extremely strong and clear way. I've already said that. But I'm trying to think about how best to sort of say, passing laws takes resources. it also impacts people inherently, right? Every time any law is passed, it's going to affect a population. It will change the status quo for some people. When we needlessly change the status quo repeatedly, we can suppress us activities, whether it's voting or otherwise. So I think the purpose of doing these things is to play into narratives that are essentially conspiracy theories about what's going on with elections, and to do so in a way that becomes a self-fulfilling prophecy, that creates a longer-term foundation for increasingly restrictive laws. There is a point at, you're right, we go back and forth about voter ID, and it may or may not be all that meaningful at the end of the day, but the reason it's not meaningful is because of the push and pull. It's because there's someone on the other side to push back when you have somebody saying, okay, we're going to require everyone to have real ID in order to vote. I don't have a real ID according to the federal government. So, that would be a real barrier. Mm-hmm. But as we increase that, if we make it more and more available, then we find ourselves in a situation where, okay, then we say, well, it was just a wash. What was the point anyway? But now we've poured so many resources into that whole process. And to what end? What did it accomplish?
Any other thoughts from you guys, or closing thoughts?
Apologies for the a little vehemence.
Fascinating, yeah. I think our state is in a really interesting and perhaps scary time. I mean, we have a lot of people that are moving to Montana, and we have a lot of influences from out of state, and so we're changing, and that can be good. Change can be very, very productive. But we're also in a highly politicized environment. And so I think that, there's a lot of reasons for young people in particular to be worried about their future. And so all of these issues seem to be at play in your case, and that makes it really interesting. And a lot for one judge. I mean, that's a lot for one judge to weigh upon his soul. And you may find that he takes a bit longer to rule than you want. But yeah, very interesting and terrifying, honestly, at the same time.
His dad was one of the best criminal defense attorneys. I will just say in closing, the Montana Constitution currently, there's rumblings, right, about, and this goes to what Tasha was just saying about, is it a liberal red rag that needs to go? I absolutely disagree.
The answer is no.
Right, I absolutely disagree. It's actually a very beautiful document that has, if you delve into it, and if you haven't read the ConCon transcripts or the study commission, I brought my little nerdy, these are the commission study. This was written by a guy named Rick Applegate, who's basically single-handedly undertook to draft comments for the new Bill of Rights. And it's amazing. So these are online, dig into them. Professor Johnstone just wrote a book. Fritz Snyder wrote a book about the Montana Constitution. They're amazing. Dig into the transcripts. And if well-known didn't teach you anything, and it probably didn't, or at least I didn't, invoke it, use it. Don't just fall back on the federal Constitution. In fact, the federal Constitution should, if you're doing habeas work, you should always invoke the federal Constitution, but yes. It shouldn't be the first thing you say. The first thing you should say is Judge, dignity, and Batson, or the 14th Amendment, or the 13th Amendment, whatever you want to use. But don't forget about it, because if Justice Baker's ready to hit that nail, and you're going to get new pattern instructions because of a footnote, for crying out loud. So it's a great document, and it's awesome.
As I'll talk, some of you will hear me drone on tomorrow, and listeners can see on Zoom if you listen to this podcast in time. The Montana Constitution is one of a very, very few, I think about 3 in the country, that has an explicit right to earn a living. So if you think it's a left liberal rag, that's a pretty libertarian left liberal rag that guarantees a right like that. So I think we can all agree it's a great document for the state from 72, and it's worth celebrating. It's worth litigating,
And we're going to learn about more of those in months and years to come on Short Circuit. And these wonderful practitioners will be creating that law that we'll be talking about. So a big round of applause for them. And to the listeners and everyone here, I hope that all of you get engaged.